the petitioner's case, and the appeals court poo-pooed that.
That was guardianship. That was in the case of LH.
yeah.
Guardianship case.
Yeah, and over a very scathing dissent, the appeals court just said, well, the exception, the objection wasn't timely or something, with ignoring the really terrible work, as I read the case, by the lawyer in that case. So I'm very uncomfortable doing that, and I think ultimately I would probably stand up for what my client wanted in this case. I don't like guardianship particularly. I think some guardianships are warranted. In this case, it may be a case where it's warranted because he desperately, apparently, needs it. And I don't want to be standing in court with him sitting next to me taking a position that's contrary to what he's telling me.
I think Judge Agnew,
Just from a sort of practice standpoint, when I've faced this issue a number of times, it's in the context of people who are civilly committed and need to be discharged. And through the process, a temporary guardianship is obtained. We reach some sort of an agreement on extending it with a shorter review of the orders. And that way it's a bit of a compromise between what's clearly been stated by the client and what CPCS counsel is doing in terms of a temporary deprivation or a temporary suspension of that autonomy in order to achieve long-term goals. And sometimes it turns out that temporary guardianship may be extended 3 times and then just dismissed. And we achieved both goals. So there is a way to do this that works for everyone.
okay. Bob, a quick follow-up. I think Judge Agnes totally got that right in appeal. But for the cases that in this one, the hypothetical, what does that give any administrative policy implication? So if you would stand up for this one and say yes, if you, Bob Fleischner, would stand up and say yes, I want to endorse this guardianship, what policy implication, if any, is there on an administrative level?
What policy implications are there?
So what I understand is that counsel can't do what you would advocate for.
Well, I don't know that the CPCS standards, I'll ask Karen, so rigid that I'd be taken off the list, which would love it.
I know, I keep coming back to Bob, and I hooked him in yet again. I think that in terms of following your client's expressed interests, the standards are clear. But I also think that having the burden on the petitioner to meet their burden of proving incapacity and that there is no less restrictive alternative, that's not what we are requiring. That's what the statute requires. And so I agree with Bob, and, in terms of trying to do what your client is asking you to do, but I guess I just don't find this hypothetical as written to meet the standard in terms of the client having anxiety and wanting the label, having the label and the imprimatur of the court on the label of a guardianship and the imprimatur of the court. If that's the reason that the client is seeking guardianship, I'm just concerned that that doesn't meet the standard. And yes, you don't want to be in a position of, having your client's expressed interest be, at variance from what you are advocating for. But, so I'm uncomfortable with that. I'm also uncomfortable with somebody saying, where the standard isn't met or for a reason that doesn't meet the standard to be invoking the court's imprimatur and a deprivation of liberty, for that purpose.
Would you suggest to your client?
You deserve a round of applause at the end for coming
Would you
up.
suggest to your client that they execute a healthcare proxy or a power of attorney?
Yeah, no, absolutely, and I think that was what we were suggesting, but I think then Gary offered back, when I say exploration of alternatives, if the decision-making capacity is such that there is an alternative like a healthcare proxy, a durable power of attorney, supported decision-making, signing a release form so that mom can attend team meetings or whatever it is that gives that sense of comfort to the client without having, a court adjudication of incapacity and what we call a civil death be imposed, that is, that's an alternative. So,
Shockingly, we don't have a consensus of everyone in the room about what will happen.
Wait till next.
I do think something that came up, and I'm just going to touch on it briefly and more for the, Bob mentioned the Guardian Care plans. Guardian Care plan reports are required annually, and to say that they're not filed annually in most cases is very true. There is a mechanism now that the court is implementing to require the care plan reports to be filed, and if they're not filed, frankly, you will not be happy to hear this, Carlos. There's going to be a lot of guardianships that are going to be dismissed, and then frankly, when people are going to end up having to refile guardianships and do this work again. So I would suggest, if you're a guardian on any matters, that you file your care plan reports and to kind of reach out, if you're counsel on cases where everything else is going well, to reach out to the guardian and to send them to the link on the website and indicate that they have to file an annual report, because otherwise the matters are being called into court now for reviews. And as your counsel on the case, you're going to be noticed of that matter's on for review, et cetera, et cetera. So just a word to the wise.
Before wrapping up, I want to thank Karen for coming on up, knowing what the issues were, and knowing that you'd be touched
firing
with...
squads.
Well, so I just want to get a round of applause for Karen for coming on up anyway. And for everybody in the panel, thank you all for coming.